Good morning, and thank you for joining today's Employment Update webinar. This is actually the first of two webinars, the second of which will be held on March 2nd, also at 10:30, on a couple of different topics. Today's webinar was supposed to feature Doug Solomon from Genova Burns, but he won't be able to join us today. Judy will talk a bit more about that and how we're going to handle that in a minute or two. However, we do have Dina Matalone,
it's okay.
Matalone and Brigitte Egan, also both from Genova Burns. They'll be discussing issues dealers need to consider when developing a COVID vaccination program. But before we begin, just a few quick housekeeping details. On the right-hand side of your screen is a control panel. Take particular note of the questions tab. During the call, all participants will be muted. If you have a question during the presentation, we ask that you write it down. We'll give you a heads up when the webinar is winding down, and you can submit your question in the questions tab if it hasn't already been answered. And Dina and Brigitte, you can ask pretty much any COVID question. If they're able to answer it, they will. If it's something that needs to go to Doug, they'll get it to Doug and get back to you. But now I'd like to turn things over to Judy Van so she can introduce our speakers more completely. Judy?
Okay, good morning. Thank you, Brian. And good morning, everybody. Thank you for joining us this morning. Unfortunately, we plan, and sometimes we don't always know when somebody's going to fall ill. So we wish Doug a speedy recovery. This morning, most of you know Dina, and I'm gonna give you a formal introduction of Dina, but we also have Brigitte Egan, and she's also presented several times for NJCAR and is very energetic in her presentation, as well as Dina, and I'm sure they're gonna be able to answer most of your questions this morning. Brigitte Egan is counsel at the firm's Newark office with employment law and litigation and human resources counseling. She handles terminations, employment discipline, sensitivity to employer risk and exposure, which I'm sure you are all dealing with today. She will also be speaking at the next presentation on medical marijuana issues in the workplace. Ms. Egan conducts sexual harassment, discrimination, and whistleblower investigations as an independent investigator, and she leads group and one-on-one training sessions for employees. We were speaking earlier, she said she had a 3-hour workshop, webinar workshop last week. So she's very in tune with this new way of training. She served as editor of the New Jersey Employment Law Letter, and she authored Taking He Said, She Said to Trial, published in October of 2006. Dina Matalone is a partner at the firm's Newark and Tinton Falls, New Jersey office. She's chair of the Human Resources Counseling and Compliance Practice Group, and a member of the Employment Law and Litigation and Criminal Defense. Ms. Matalone has extensive experience training businesses and human resources organizations on matters involving anti-harassment and diversity policy compliance, best human resource practices, hiring and documentation, and discipline. She conducts on-site harassment and whistleblower investigations and pay equity audits, and she drafts and negotiates employment-related agreements, including confidentiality, non-compete, and separation agreements. I know Dina also works very diligently in many associations. She holds various positions in the New Jersey State Bar Association and the New Jersey Women Lawyers Association, and she's an advocate for mentoring and advancing women lawyers and increasing the involvement of women in professional and charitable organizations. So we are very pleased to have both of these valuable women with us this morning to answer a lot of our confusing questions on what dealers need to do requiring the COVID-19 vaccination. So with that, I'm going to turn it over to Dina and Brigitte. I think Bridgette's going to start. And thank you so much, ladies, for joining us this morning.
Thank you, Judy. Welcome and good morning to all of our attendees this morning. As Judy and Brian mentioned, Brigitte and I are going to talk this morning about requiring the COVID vaccine at work. I'm sure many of you have been thinking about it or reading some articles about whether or not you should be doing that at your dealership and whether or not you want to make the vaccine voluntary or involuntary. Brigitte actually was just interviewed by ROI New Jersey in an article entitled "Shot in the Dark: Can Employers Mandate the COVID-19 Vaccine, and Should They?" And I think that "should they" is an important question that we want to explore this morning on the webinar. And Bridget will kind of take us through some issues and some guidelines if you are thinking about mandating the vaccine for return to work. And I'll talk about accommodation issues for those employees that may have be eligible for an exemption from that requirement for the COVID vaccine. So Bridget and myself, Doug Solomon, who unfortunately couldn't be with us this morning, we've been living and breathing, for lack of a better phrase, COVID for almost a year now. And it's kind of hard to believe that we are approaching almost the 1-year anniversary of the New Jersey shutdown for COVID. So we'll answer questions at the end of our presentation this morning. And if there are questions with regard to other areas of COVID, we're happy to try and answer as best we can the questions. And like I said, if we need to follow up with you with Doug Solomon or someone else in our office, we're happy to get back to you. So with that, I'll turn over our introduction and we'll get started with Bridget.
Thank you, Dina. Dina, I think we can go to the first slide.
Sorry.
Dina, okay, here we go. All right, good morning, everybody. Thank you so much for attending. The big question is, as Dina said, do you require the vaccine? Do you make it voluntary? Do you make it mandatory? And there's been a lot of discussion that this current vaccine or the vaccines in progress now in being implemented have emergency use authorization and have not gone through the FDA vaccine licensure approval, which is the normal, the flu vaccine, the polio vaccine. All of our vaccines go through this very long process. But here we have this abbreviated emergency use process. And there's been a lot of debate upon whether an employer can require an employee to be vaccinated with this emergency use authorization. And the short answer is yes, it looks like employers can require it, but we have to build in some exceptions that comply with our state and federal employment discrimination laws. Dina, we can advance to the next slide. With the emergency use authorization, there is an obligation with the FDA to let employees or to let anyone in the community know it's voluntary to get this vaccine, and there are some risks that are known and unknown and benefits that are known and unknown. And there are alternatives like masking and not taking the vaccine. This information is communicated through an insert that comes with the vaccine, a fact sheet. Now, why is this important to you? Some employers are considering requiring the vaccine to be given either on site, if they have a policy saying the vaccine will be a condition of your employment, you must take it. Some will have like a flu shot clinic, a COVID vaccine clinic on site, or they may contract with a certain vendor to administer the vaccine to its employees. And the question is, with this emergency use authorization, will the employer now have the burden of doing the FDA's component here of informing employees of the risks and the benefits, the emergency use conditional authorization? This is only an issue if you, the dealership, administers it. So if you require the vaccine, but you say, employee, go to a super site, go to your healthcare provider. This is the deadline where everyone must be vaccinated. You can tick this issue off your list. It's not your responsibility at that point. So beware, if you have that on-site clinic and it is mandatory, you have to deal with this issue. The government has not told us how to deal with it yet. We're learning as we go, as we have the whole year with COVID. But the suggestion is tell employees, roll it out with training, inform employees to look at the FDA website, provide that website. As you'll see during this seminar today, we will tell you if you require the vaccine, It's easier for you, less burdensome, less regulations to comply with if you let the employees go off site, just give them a deadline and understand that we have hiccups with the vaccine roll-up, but when it's released to the general public, work with your employees and have some third party who you don't contract with do all of the administrative work. And that way you don't have those requirements and more liability and exposure as well. And the next. So we can require the vaccine. And the EEOC guidance is, it comes outright and says you can require proof that your employees have taken the vaccine, but it just assumes there's no direct answer. Can we require the vaccine at work? The EEOC guidance assumes that you can, with exemptions. If someone cannot take the vaccine because they have a medical condition and the vaccine would be unsafe for them to take it, or if they have a religious belief and or objection based upon a sincerely held religious belief that taking the vaccine would go against that belief. So again, we have federal law, the Americans with Disabilities Act for medical conditions, religious beliefs, Title VII of the Civil Rights Act, and the law against discrimination are state law, which have these carve-outs that we will have to comply with if we require the vaccine, a term and condition of coming to work every day. Next slide. If the dealership requires the vaccine, an employee says, wait, I can't take it. I have a medical condition that will be aggravated by the vaccine. It's unsafe for me to take. We now have a requirement that excludes or screens out people with certain medical conditions from going to work. And that triggers the Americans with Disabilities Act. In that type of situation where we have that first employee who says, wait a second, not me, I can't take the vaccine because of my medical history, we have to go through a person-by-person individualized analysis to see if having that unvaccinated employee at work would, and the legal term is, pose a direct threat to a significant risk of substantial harm to the health or safety of the individual or others. What that means is, if we allow that unvaccinated employee to attend work, can they be a harm to themselves or others? And is there a way to reduce that harm and still allow them to come to work? That's the analysis that must be done when you get that first objection. Next screen. And the EEOC wants us to do the work. They want us to consider 4 different factors when doing this analysis for each employee. And again, this is only when there is a medical objection to taking the vaccine. The EEOC, you'll see the 4 factors. They want us to look at how long is this risk to safety? What is the nature and severity of the harm? What is the likelihood that the harm will occur? And will it occur quickly to others? Now, given that we're still in the pandemic and about 5,000 people a day in New Jersey are testing positive, the duration of the risk is unknown because we don't know when the rollout to the general population will be, when everyone will have that vaccine. We don't know if the vaccine will be effective or how effective against the variants that are out there. The nature and severity of the harm, it can be death or less, but it's a severe harm. The likelihood that it will occur, if you're a dealership that has been shut down because too many employees have become infected, or if you're not, but you've had quarantine issues, close contact issues, there is a strong likelihood that people will get sick. We see it every day with these numbers. They're not low like they were in the summer. And the imminence of the potential harm, everybody, unfortunately, is a moving target. Even when we mask, we're all human. We still have instances where we take the mask down, where we come in close contact. And dealerships, employers, I hear it all the time with the phone calls. We can't babysit and monitor everyone all the time. So all of those factors work to establish that if you have an unvaccinated employee, it's dangerous to that employee and to others. Now, the flip side, if there is a litigation, what arguments can we expect to hear from employees? Well, we've been working for a year. We've been masking for a year. We social distance. I'm not at a dealership where many people have gotten sick. You should not exclude me. That will be the debate. Those will be the litigations that will come in a year or so. But right now, the EEOC's guidance is very, very clear. Okay, you can have a policy that requires the vaccine, but you must go through this risk analysis. And odds are, given where we are right now, the policies will be okay. What can change that? With the vaccination, if lower numbers of people infected, if we return to the summer where we have 400 a day instead of 4,000 or 5,000 a day. So, it's a snapshot in time, and that's why it's so important to do this analysis as you roll out your policies, as you enforce your policies, and as you get exemptions, requests to be excused from the requirement. Next slide. So what happens? You have an employee who says, I can't take the vaccine. We have determined that it's dangerous for this employee to come to work. Can we tell that employee stay home? The EEOC says, no, we have to do some more work, dealerships, employers. We have to go through another analysis that Dina will talk about a little bit more. Can we accommodate the employee and their medical condition that precludes them from getting vaccinated at this time? Some of those accommodations, and Dina will go into this, can we make the work environment a safer place for everyone? If not, are there leave rights available? The EEOC tells us employers, you cannot automatically terminate someone because they cannot get vaccinated due to a medical condition. Next slide. Some of the things that we want to consider when we're going through this analysis of whether we can accommodate an employee. The EEOC tells us, look at if you know how many employees in your dealership already have the vaccination. Do you have basically herd immunity within your own dealership, so that if you introduce someone who's unvaccinated, the likelihood of someone getting sick is slim. While the EEOC tells us to consider this factor, they also say to look at the CDC recommendations and OSHA guidelines. And right now there's a strain of thought, and you read about it in the newspapers every day, what's happening with the variant? Even if people are vaccinated, will that vaccination protect them from the variant? So again, we're in static right now. It's a factor. How many people have gotten vaccinated is a factor to consider. But again, this might look different next month when more people are vaccinated. Maybe the variant has gotten stronger. We'll now have data to see if that vaccine is effective against the variant. And if so, maybe it is easier to introduce people back into the workforce who have not been vaccinated. Again, the most important thing to take away from here is what happens today. The data will change within weeks, within months, and we will constantly be revisiting our policies and our decisions during this process.
Thank you, Bridget. I'm going to take a little bit of a deeper dive into the exemptions of having employees opt out of having the COVID vaccine. And the two issues that Bridget had discussed were religious accommodations, right? And that was one of the two, and I'm going to start with that. Bridget mentioned the EEOC has always had guidance saying that employers are obligated to accommodate an employee's sincerely held religious belief. Those who have worked with Bridget and I in developing and updating employee handbooks And for those dealers that we don't work with, I'm sure your legal counsel has advised you of that as well. Employers are required, even taking COVID out of the scenario, to accommodate an employee's sincerely held religious belief. So if you have an employee handbook, be sure to check and make sure there is a religious accommodation policy contained in that handbook. So what does sincerely held religious belief? Well, that is a good question, and I'm going to get into that in a second. But if you have an employee that claims, I'm unable to take the COVID vaccine, or I do not feel comfortable taking the COVID vaccine due to my religious beliefs, we always recommend and counsel our clients to get that request in writing, because you do not have to accommodate secular or medical beliefs about the vaccine. If your employee says to you, I feel uncomfortable, I don't trust the data, I don't believe what the CDC is saying, I distrust Dr. Fauci, and so that is not a reason, right, not to take the COVID vaccine if you are going to require it in your workplace. I think that, just like if you're still having ongoing issues with employees who are afraid to return to work, or employees who are afraid to work alongside someone who may have had the COVID vaccine and or who has recovered from COVID, fear is not an excuse not to come to work when you're talking about COVID. So similarly, when we talk about religious exemptions, right, you don't have to accommodate secular beliefs or beliefs that science and data are incorrect. So if once you get a request from an employee who's requesting an accommodation based on their religion, consider using a religious accommodation request form. It's proof for your dealership that the employee is requesting the accommodation. It asks questions as to what their religious beliefs are and what the basis is for their objection. And they are also swearing in a written document why they object and feel that they are not subject to the employer's mandatory policy. And it's really important. And I say this at our seminars as well, when we talk about FMLA and ADA leave of absences, where people say, I suspect that my employee is not really sick. I feel that they're down the shore or they went on vacation, and I know it, and they aren't suffering from a disability. And so this is similar, right? So this will provide proof if in the event you can prove that the employee does not have a sincerely held religious belief that would exempt him or her from the COVID vaccine. The information that's contained on the form could be a firsthand explanation from the employee themselves, or it can be verified by a third party. But be mindful that third-party verification does not have to come from a religious official or member of the employee's religion. So I don't need a supporting certification from the pastor, the minister, the priest, the rabbi, etc., in order to grant the religious exemption. And before COVID, Bridget and I had to deal with religious exemption issues when we were just dealing with employers that were requiring the flu shot. So these religious exemption issues have always been around. You may not have had to deal with it, but Bridget and I represent some large medical employers here in New Jersey, and we've always had this issue with employees who have refused to take the flu shot. So be very aware. But this verification can also be provided by others who are aware of the employee's religious practice or belief, right? So it could be a friend, a relative, etc. The EEOC, as we all know, they're our watchdog in the workplace, encourages employers to assume that the request for the religious accommodation is based on a sincerely held religious belief. So that is a high standard. You will have to accept the documentation from the employee as true. And then if you want to reject it it's a high burden. So if the employer has an objective basis for questioning the religious nature or the sincerity of the religious belief, you can justify seeking additional supporting information. So in the first instance, what this means is, in the first instance, you have to accept the employee's explanation, and again, get the religious accommodation form. We're happy to assist you in that process. Those of you that are our clients, you already have the form, because this issue of religious accommodation has maybe come up in when employees want to take off on holidays, that you're requiring them to work, etc. But it's the same form. And be mindful that you can't pry for too much information, right? Because then you're going to be in an issue, you're going to have an issue as well. And then the failure to accommodate an employee based on their religious belief exposes the dealership to liability, not only under federal law, as Bridget mentioned, Title VII of the Civil Rights Act, but also our New Jersey law against discrimination. Obviously, religion is a protected category. I also now want to turn, let me just see if I can, I'm having an issue advancing the slides, but let's see if I can do it. Sorry, I'm having it like, oh, there we go. Okay, so everyone, I hope, on the call understands that when employees do have a medical condition, the employer has to interact with the employee under the ADA. That is the employer's obligation. And how do we, what do we do when we have an employee that says, I have an underlying medical condition and I cannot get the COVID vaccine? And so obviously that could be employees, that may have severe allergies. There's, some data out there that suggests that if those that have severe allergies may have a reaction to the COVID vaccine. There's some discussion about whether or not it's safe for pregnant employees, as an example. So what do we do when we have those employees? Well, we have another form. It's called the Interactive Process Questionnaire. And you send that to the employee so that they can send it on to their physician. And the questionnaire asks the physician to answer questions so that you can determine whether or not you want to accept the employee's explanation as for the exemption. So the questions are going to ask the doctor the nature of the employee's impairment, the duration or the need for the accommodation, and to the extent it conflicts with the vaccination requirement. So you may get something from the doctor that says, well, it's my suggestion that the employee waits for, I know the Johnson & Johnson vaccine has been news reports that that's coming out. It's only supposed to be one shot. It may be safer for those with underlying medical conditions. So perhaps the doctor comes back and says, Bridget's not ready yet for the vaccine. We want to wait to the next round of vaccines comes out. And then, we will revisit this. So that's all, what may come back in that interactive process. Be mindful that if you want to call the employee's doctor or follow up on any questions, right, that you have uncertainty about on the interactive process questionnaire, you have to obtain a HIPAA release from the employee's doctor, from the employee, in order to communicate with the employee's physician. That's very, very important. So what are accommodations? If an employee comes back and says, I can't take it, I don't want to take it, it's verified by a doctor, or they are subject to the religious exemption. We need to start thinking about, and I know we do a lot of work with dealers, it's hard to think about remote work, right? Obviously, technicians cannot work remotely. The service advisors cannot work remotely if they're interacting with customers. But I think, some jobs in a dealership can be done remotely. Make sure, you are enforcing social distancing. Very, very important, because Bridget and I get calls every day where, and we've had these calls in the past year of sections of dealerships having to be shut down because no one is social distancing, right? We all, I hope, understand that what it is. It's 6 feet, it's it's up to a cumulative total of 15 minutes or more. So when you call an attorney or your legal counsel, or you're thinking about who has been in close contact with my COVID employee, the answer should be no one. If you're doing a good job of enforcing social distancing, not having people gather in lunchrooms to eat lunch unmasked, the answer to who has been in close contact should be no one. And then you won't be, hopefully, in a position where you may have to shut down service or parts, etc. Masking, I talked about. Shift changes. Can we change shifts? Can we change the location of certain individuals in the dealership so that they are able to social distance? And in the end, if we can't do any of the above, we should be thinking about and giving employees an unpaid leave of absence until they are able to return to work. So Brigitte also talked about, how do we determine if an accommodation poses an undue hardship? Okay, undue hardship is a trigger word for the EEOC and needs to be a trigger word for all of us as employers. Undue hardship, according to the EEOC, is more than a de minimis cost or burden. Increased cost to you as the employer is never an excuse not to accommodate an employee. So many dealerships, my office as well, we've put up signs, we've put up markers on the floor for one-way entry and exit. We've closed down stairwells to be only one way. We've added plastic partitions, right? That is not, and that costs money sometimes, right? Those plastic partitions cost a lot of money. Cleaning our dealerships costs a lot of money. But that is not a criteria to say to someone, we can't accommodate you, right? The EEOC doesn't want to hear what the cost is to the employer. So the EEOC has said, if there is no reasonable accommodation possible, then you can lawfully exclude your employee from the workplace. And so you want to think about all of the sample accommodations, that I just talked about: social distancing, working remotely, moving workstations. You want to be able to kind of like go through that analysis and say to the EEOC, if they come knocking, oh, we tried everything. The only other thing to do is to exclude the employee until they can get the vaccine. And again, don't think that the EEOC is the only one that's going to come after you. We also have the state to deal with, the Division of Civil Rights, and we have the Department of Labor. And that will be subject, what Doug's going to talk about on our makeup session is those of you may have already received inquiries from the Department of Labor, and that's coming. We've helped several dealerships kind of deal with that as well. Pre-screening questions. Brigitte really talked about this. If you mandate the vaccine and you contract with a third-party vendor that comes, like we have annual flu shot clinics at our firm every year, and what the EEOC is saying, you have to be very, very careful the pre-screening questions that are being asked. Because that all elicits medical information, right? So right now, if you're using a questionnaire to say to an employee, do you have a fever? Do you have any symptoms of COVID-19 in order to come to work? That is all protected health questions, right? And you have to be very, very careful that you are keeping that information confidential. Any communications and documentation concerning requests for an exemption or questionnaires that employees are filling out where you're asking them about medical symptoms, that all has to be kept in a separate file. That has to be kept in the employee's medical file, which is separate from the employee's personnel file, and you need to make sure that you're doing that. Otherwise, it's going, you're going to have breach of confidentiality, and the employee's going to have claims under federal law, state law, and under HIPAA. I already talked about this, so I can kind of skip ahead. Gina. I don't know, Bridget, do you want to talk about Gina inquiries a little bit, or actually I can, it's fine. The Genetic Information Non-Discrimination Act is a federal law that prohibits employers from making employment decisions based on an employee's genetic information. And it's funny, when we run anti-harassment training, we always kind of put this slide up and people say, you know, how is my genetic information protected? And basically what that means is if there are any pre-screening questions about family history, right? We all know when we go to the doctor's office, there's a question on our initial questionnaire that asks, what are your parents' underlying medical condition? Do you have a family history of, right? High blood pressure, diabetes, stroke, cancer, breast cancer, right? These questions are on every form we ever fill out when we go to a doctor's office. And that's fine when you're interacting with your physician. But those are questions that can never be asked, right, by the employer. So you have to be really, really careful. And sometimes, you know, when you're pre-screening people for COVID, you have to make sure that there are no questions, right, about family members on those forms. Very, very important. If they, you know, and you have to also inform employees when providing proof of the vaccination, we don't need any of that other information. So we don't care that the husband, their spouse, or their partner, or their children, or whatever it is, also have the COVID-19 vaccine. That's none of our business, for lack of a better phrase, with our employees. Whether or not their family members are vaccinated has nothing to do with us. So you are also allowed to require proof of the vaccine. You're absolutely, as an employer, allowed to get a copy of the vaccine certificate that they're giving out. So that's really important as well. And the EEOC said, that's fine. You can obtain that information as well. I'm just, right. Asking why they did not take the vaccine, right? That's an issue. Again, we're going to interact with them under the ADA, et cetera. Bridget.
Yep. Mandatory vaccines. You have your employee. So I'm the employee who would love my employer to say, okay, everyone, we're going to reopen, but you must take the vaccine, because I don't want to get it from the guy sitting next to me. So I would be the first in line. You wouldn't have to give me an incentive. The guy sitting next to me does not want to take that vaccine. The guy sitting next to me thinks that the whole thing is politics and overblown. He has different views than I do. And the dealership, what will you do? What will you do with the guy sitting next to me? If the reason why he doesn't want to take the vaccine has nothing to do with a medical condition, it has nothing to do with sincerely held religious beliefs, which you can see, I bet you we're going to see a lot of those types coming in right now. Wait a second, I need a religious exemption because Dina explained how easy it is to get one. We're not dealing with those people. We are dealing with, I just don't want to take it. I already had it. I'm not going to get it again. It won't be so bad. It's politics. What can you do with that employee? As long as you have a policy and as long as you are consistent in how you discipline, discipline is an option. Now, the guy sitting next to me is my law firm, the highest biller in the firm. If we give him a pass, if we are flexible in our deadlines with him, but we're not with the female 2 doors down from him, we're going to get discrimination claims. We're going to see new litigations and lawsuits. So if we are going to take a hard stance on the vaccine, we should have a policy. The policy should lay out the consequences. And as with the discrimination laws that you've been dealing with forever, you want to be consistent. That is the key. Dina, we can go to the next one. Now,
Sorry, I'm stuck a little bit.
that's okay. And maybe there is a different approach to this. Maybe you want to strongly encourage your employees to take the vaccine instead of taking the hard line, which will force you to take an action at some point. Do we want to have training? There will be companies that will come in to tell your employees how great the vaccine is and how safe it is. Just as we come in and we do your anti-harassment and anti-discrimination training, there will be training on the vaccine. Is that an approach you want to consider? Do you want to rewrite your job descriptions to have the vaccination as an essential job requirement for people dealing with the public, for people where it's hard to maintain certain social distancing requirements, even though we're supposed to? And do we want to build into that policy, build into those job functions, discipline or termination? These are all the open questions that, as you think about the vaccine, you'll want to think about what your dealership will stand for as far as dealing with your employees and the representations that you want to make about how safe the dealership is as well. So is there an answer? Yes. You can require the vaccine. We know that from the EEOC. If you follow the exemptions for religious and medical reasons for not taking the vaccine, carve those people out. We have to treat them different and better under the law than the pure objector. I don't want to do it. You can take action, be consistent. Next slide. So for my employers who want to encourage instead of mandate the vaccine, I've already gotten phone calls on this because everybody's being proactive. Can we give an employee an incentive to take the vaccine? I've gotten questions about gift cards. Can we offer more PTO? The area of this law has to catch up to COVID. Before we talk about what the law is, we have a group of employers who's already petitioned the EEOC for clearer guidance on the COVID vaccine and incentives that can be offered, because it's not developed yet, not all the way. What we do know is that if an employer does not link the incentive, take the vaccine and I'll give you a $100 gift card. If we do not link that bonus to your group health plan, your medical plan, you have much more flexibility. There are tons of rules and limitations once you link it to your group health plan. So again, you want to make a voluntary program outside of that. You want it, and voluntary is the key word here. Just as the vaccination program, voluntary with incentives. If someone does not want to take the vaccine in your voluntary program and they'll forego the incentive, you cannot take a disciplinary action or retaliatory action against them. Again, this is where you might see claims. So if you do roll out incentives, you want to have a clear policy that has a no retaliation piece, as with someone who makes a sexual harassment complaint or a race complaint. People who cannot take the vaccine for religious reasons and medical reasons, we can't discriminate against them. We have to make the incentive available to them. How the heck do we do that? We have to think of another way, meaning those people can take trainings, watch videos, take education on how to be safe, the social distancing, the masking, whatever the state of the time is at that moment. If they sit through those trainings, they will be eligible for the incentive. So we can't discriminate against people who, for medical or religious reasons, cannot take the vaccine when we have an incentive program. How much can we give? This is where the law is very, very unclear. The law tells us in proposed guidance, that the incentive has to be de minimis, small, but we do not know what that is. The EEOC tells us we can give gift cards, but they don't tell us how much. We can give water bottles, which kind of, balances out when you think about small. The gift cards can't be too big. Can we give PTO? It's going to depend upon the employee's hourly rate and how much PTO we're going to give, because we have to justify this de minimis standard that is undefined. So again, a whole bunch of employers have petitioned the EEOC to quickly roll out guidance. And what we have seen during the pandemic is that the EEOC has been pretty responsive with the guidance. So this is a more to come. The EEOC has told us gym memberships for a year, they're not de minimis. For some reason, the EEOC has given the example of airline tickets, trips, you could fly once you get the vaccine. The EEOC has said that's not de minimis. But there is this vagueness, and we will, provide updates as the law becomes more evolved in this area. But we have to think small for now with the incentives.
Thank you, Bridget. You couldn't hear me chuckling when I was thinking about airplane tickets. I drove by Newark Airport this weekend, and it's so funny. Like, I used to see so many, those airplanes would just fly right over the turnpike, and you'd be almost like driving into them. You think they're going to land on the turnpike, and now you barely see any, planes flying in and out. But people are flying, and hopefully, there will be a return to that. So what can we do now, I think, as the go forwards that we need to be thinking about in 2021? COVID-19 written plans. Doug will talk to you about that in our makeup session. The Department of Labor is stepping up enforcement on all employers, employees. In Governor Murphy's one of his last executive orders, he empowered the Department of Labor to issue fines and investigate employee complaints for failure to follow COVID social distancing, return to work policies, et cetera. So we've definitely seen stepped up enforcement by the Department of Labor. A written vaccine policy, like Bridget said, if you are interested in mandating the vaccine, if you're interested in mandating it for certain employees at your dealership, you must absolutely need a written vaccine policy. If you have certain employees who are continuing to work from home, even if you have employees that may have to quarantine due to close contact, and there is some work that they're able to do at home, do you have a remote work policy, which describes the expectations of the employees, when they have to log on, how many hours they have to work, and what you expect to them in terms of output and in terms of production. That's really important to have a remote work policy, and even to go a step further, to have a remote work agreement with those employees who are continuing to work from home. Stop the spread policy. Those are just our posters, right, that are in our bathrooms, up all over the dealership about washing our hands and maintaining social distancing. Temperature checks or questionnaires. Don't forget that Governor Murphy's executive order is still in place. We have, as New Jersey employers, have to choose as to whether or not we want to conduct temperature checks, or if we want to subject employees to daily questionnaires to ask them whether or not they have any symptoms of COVID-19. And also important, you need to update your New Jersey family leave law policies and other leave policies to account for COVID. The New Jersey family leave law was amended, as everyone understands, to allow for school closure leave. Hopefully those requests are dying down now. Not many people are requesting it, but some and a large majority of New Jersey schools are still opting to go remote, or at least on a hybrid schedule. So even though the FFCRA, the Families First Coronavirus Response Act, is now only voluntary to the end of March, to March 31st, 2021, don't forget that you still have the New Jersey Family Leave Act that requires employers to give those employees who qualify leave for school closure. So I've had a lot of clients who said, like, well, FICRA's over and I don't have to worry about it anymore. And I said, no, you still have to worry about the New Jersey Family Leave Act that allows for that closure. And unless and until the New Jersey Family Leave Act is amended, that's what we're left with here in New Jersey. So make sure that you're considering those policies as well. So we'll open it up to questions. If any, Judy, I don't know if you want, Brian, if anyone has any questions, we're happy to take them. Or if not, you can always follow up with us in an email, and we're happy to get back to you and follow up as well.
Thank you, Dina and Bridget. That was really great. And I just wanted to make an announcement to everybody on the line that we will be following up with Doug Solomon's presentation. He will be diving more into the OSHA section of the presentation. But right now, I think if anybody has any questions regarding policies, procedures, or any of the things that Dina and Bridget spoke about, you can type them into the chat on the questions portion of the screen.
Hello, it's Brian. We have one question. As Judy said, if anybody has any others, please submit them in the questions tab. The question we have here is: can an employer require an employee who is out of work after testing positive for COVID to present documentation of 2 negative tests given 24 hours apart upon their return?
So the answer to that question is yes, but you need to have a written policy and a policy that you're uniformly enforcing. So you can require as an employer to have policies over and above what the CDC recommends. And this is an interesting question, Brian, because I got a phone call right before this webinar from one of my dealer clients where they had an employee who tested positive for COVID and is continuing to test positive for COVID. The CDC guidance, Bridget and I talked about this earlier before this webinar as well. The CDC guidance has said that employees can continue to test positive for 3 to 6 months after they have already recovered from COVID. So the question is, what do you do with an employee that continues to test positive? And I think that the answer to that question depends on whether or not the employee is symptomatic or asymptomatic. So if you have an employee that after 2 times, right, you mandate 2 negative COVID tests to return to work, but the employee originally tested positive over a month ago, over at least 20 days ago, and hasn't had any symptoms in 20 days. And why do I use 20 days? Because the CDC guidance is 10 days, right? 10 days being asymptomatic after being COVID positive, you can return to work. So the advice I gave to a client this morning is they're going to continue to test negative for, continue to test positive for perhaps up to 3 months. And I don't believe that you're going to be able to keep that employee out for 3 months when the CDC guidance has said they can come back even after continuing to test positive. So my answer to that question is yes, you can require 2 negative tests in order to return to work. But what I need you to be mindful of is if the employee was positive and has not had any symptoms in 10 days or 20 days, which is like those 2 10-day periods, that employee should be returned to work if they are asymptomatic.
Great. Well, either you guys were very thorough, or people are sick of hearing and talking and thinking about COVID, because I don't have any other questions right now.
Well, I have a couple questions maybe for the audience, Dina, and like Dina said, you guys can contact them at this number at any point. But sometimes, Dina and Bridget, they want to be able to do some research on their own, and there's so many acronyms that you spoke about during the presentation between the EEOC and the DOL. Where is the best place in the CDC? What is the best site for them to go and try and find information and some of the forms that you spoke about?
I think if you're a member of SHRM, SHRM, if your office managers or someone is a member of SHRM, some of the forms and the discussion points we talked about are accessible if you're a member of SHRM. For those dealers that work with our clients, work with us, we provide them with the forms as well, which we've kind of like tailored to that. But the EEOC has, their website is pretty helpful. The CDC, I think we all have a favorites tab, at least I do, on my computer with a direct link to the CDC website to try and kind of, navigate that. So it's really hard, but I think, I think good resources are always, you can always like go on blogs, our blogs as well. Like we always update everyone, and our blog is for free, and you can find that at genovaburns.com, our labor and employment blog. And if there are any updates, we push them out that anybody can sign up for, and we're really proud of that blog because we try to make it in English so everybody understands. It's the way we write the articles. It's not for lawyers. And after the presentation, we're going to provide NJ Carr with a copy of our PowerPoint, as well as Bridgette's latest employment law blog on the COVID vaccine. So I think that'll be a great resource as well. But always, like, my favorites are the EEOC, which is the Equal Employment Opportunity Commission, and their COVID guidance, as well as the CDC's guidance, Governor Murphy's website, and all his executive orders. And Bridgette, what did we say the other day? He's up to 100, and did we say what he was up to? 100.
He's near 200. He's
Yeah,
near
he's in the 200s. Yeah, he's in the 200s. He's had a busy year. Yeah.
One last question. You spoke a lot about third-party providers to come in and help them. Do you have any names that you could give them as far as who they would reach out to?
Bridgette, who have you seen? I haven't had any clients actually, because again, remember, there's no vaccine available right now. It's so hard, to get appointments. But I think eventually, the CVSs of the world and the Rite Aids of the world will eventually start coming. I forget. I know that in BioReference, Bridgette, I know they were doing testing, on-site testing.
Yeah, you can contract with some of the big labs for the services, but it's kind of funny. If you Google, COVID training, you'll see a whole bunch of brand new entrepreneurs who've sprung into action to satisfy the need. The big thing is, as I said, especially with the incentives, the law is not clearly defined yet. So should you rush right out and retain someone, one of these entities? I would, monitor. The law just keeps on changing, especially with the variant. As far as contracting with a lab to come in to help with the vaccine, that's one thing. The education piece is where I would, do my due diligence, because a lot of these companies are brand new pop-ups. So you want to do your homework with them.
So you would say that the training and having a COVID plan is the most important thing for them to get into place right away.
Yeah, the COVID plan especially.
The COVID plan especially, and Doug, Doug will talk about it, because, we've assisted clients in dealing with the Department of Labor, and we've been successful. You can't hear me, but I'm knocking on wood, with the Department of Labor, because we've worked with the dealers to have a written COVID-19 plan. And the Department of Labor, once we show them, and it's like 10 pages long. I mean, it's a pretty long document. And what our clients who have been successful with the DOL in the past, like 6 or 8 months, a large part of that has been the photographs that we send them in support of our, our defense, the photographs of the posters that we have up, the photographs of the social, the markers on the floor, how far apart the desks are, the plexiglass, that we have up, like, let's say, in between our service advisors and the general public. So that has saved, dealers thousands and thousands of dollars in fines. And those of you who have been to our prior webinars, we always say the Department of Labor, they are, tasked with investigating one employee's complaint, but we all know they're there for other reasons. So you never want the Department of Labor to come, period. And because typically they're not really there for why they say they're there. They're there for other reasons and to open it up more broadly in terms of an investigation. So we've been successful in showing all of our, closing down the lunchroom, taking, and a client has said to us, well, Dina, like, where are our employees going to eat? And I said, I know you don't like people eating at their desks, but that may be something we have to do. Or physically remove chairs from the lunchroom, right? If you have 20 chairs at the lunchroom table, take out 10 of them, and have a marker on the table as to where the chair is supposed to be. So we have sent those pictures to the Department of Labor. We've sent them our 12-page COVID-19 policy. And I said, these are our protocols. This is what we follow. The employee's complaint must be dismissed. And, and having that COVID-19 plan is, like I love to say, like your get out of jail free card. I mean, it is like when we talk about anti-harassment training, what's your best defense? That you did training and the employee signed off on it, and you had a policy and the employee signed off on it, right? So very important.
Great. Well, and then one of the things I know, Dina, we spoke about before we started, that you are an employer yourself, and you deal with this all the time with your own employees. So it's not.
I had my phone call with my client this morning who was asking me about, how do you return an employee to work who's still COVID positive? Dina, it may be easy for you to say that, and I had to say to them, no, it's not easy for me to say that. We have 140, I think now, employees at our law firm, and I'm a partner there, and I head human resources. We have a human resources director, but we're constantly on the phone talking, and we have a responsibility as well. So I understand how important these decisions are and what the legal risk is, because we have employees too. So Bridget and I are constantly dealing with this at our own firm. Very important.
Great. Well, thank you so much. Go ahead,
Judy, we're at about the 1 hour mark. Did you have anything else? But we had one more question and one more statement come in. Did you have anything else though, before I go over those and wrap things up?
Yep, go ahead.
Oh, you don't have anything else? Okay, good. Well, let's do the statement first. Brianna Esquelan, my colleague, was noting that the NJ Car Clean, NJ Cars program, that has part of that is a written manual that pulls together the OSHA, CDC, New Jersey, and federal requirements. And she said it's actually been given to the New Jersey Department of Labor on multiple occasions as proof of a COVID policy for the dealers. So I don't know if that necessarily replaces having their own policy, but I mean, Dina, I guess, could you maybe speak to that? If they've been certified?
I haven't seen the NJ Car COVID manual. I will, which I'm sure is great, as all the NJ Car material is. But the COVID-19 written plan really deals with the nuances, right? Like the question we had earlier, can I require 2 tests, right? I'm sure that's not in, right? So, because that's not in the CDC guidance, right? That's not, you're not gonna be able to find that anywhere per se, right? But the answer to that is yes, you can have requirements that are over and above, right? What NJ Car has put together and what the CDC and OSHA guidance is. So if you're interested in doing that and making things crystal clear and adding additional protocols that aren't covered by that, then you should have both. That's kind of where I stand on that.
Okay, and then the last question we have here before we wrap things up: if an employee is hospitalized for a severe reaction, or God forbid dies due to the experimental emergency use only vaccine, who is liable, since Pfizer, Moderna, and Johnson & Johnson have no liability?
It's horrible. Go ahead.
That's a terrible question, but it's an important question, I guess.
There's no immunity for employers yet. So could an employer see a claim? Yes. How would the courts how would the courts treat it? We don't know. We know that the EEOC is telling employers it's okay, but that doesn't mean you won't be sued over it. So that goes back to your strategy. Do you want to mandate? Do you want to encourage and educate? And the strategy decisions there. And how has your particular dealership been impacted? Are you one of the ones that had closed down departments or closed down entirely? So a lot of this is yet to be determined. Will there be legislation for employers? We don't know yet.
I have to I agree with Bridget. I mean, there hasn't been any, talk of immunity for employers. I haven't seen it yet. Hopefully the EEOC will say something about it, or there may have to be obviously legislation passed on the state and federal level for that. It'll be interesting to see what the Biden administration does, what the New Jersey state legislature does. I had a torts professor in law school, and his famous phrase was "sue them all." So it's very scary, as an employer to say, "Wow, I'm mandating it, and what happens if?" Right? God forbid, something happens. I get that, but we also deal with that though as employers on a daily basis. What if I bring someone back and they have COVID and I don't even know about it, right? Because that's something else I discussed this morning with one of my clients. Like I may have COVID and I'm walking around my dealership, right? I'm going to the dealership and I'm asymptomatic. So it's really scary. So and I think Bridget said it, earlier, like it's not our responsibility as employers to know everything, all the time. But what we are responsible for is what we know about and we fail to do something about it, right? So I can't police and know what one symptom. All I know is this employee told me I don't have symptoms, I can come to work. And if later on they actually lied to us, that's not my responsibility, right, as the employer. I'm only responsible for the information I have.
Right. Great. Well, thank you very much to Dina, Bridget, and Judy, and thank you to all participants. We will, as Judy mentioned, we will reschedule Doug's portion of this webinar at some point, either later in the month or sometime in March. Also, as we mentioned at the beginning of today's webinar, part 2 of the employment update is already scheduled for March 2nd, also at 10:30. That webinar will cover just as colorful of topics, how the legalization of recreational marijuana in New Jersey will affect the workplace, as well as New Jersey's pending legislation on mandatory sexual harassment training and enforcement. So we hope you'll join us on March 2nd for that important webinar as well. Otherwise, that concludes today's webinar. So thank you to everyone and stay safe.
Thank you, everyone.
Thank you.
Thank you.